Corporate Administration. Chapter 4. Corporate Meetings. A meeting is a gathering of two or more people that has been convened for the purpose of achieving a common goal through verbal interaction, such as sharing information or reaching agreement. Meeting may occur face-to-face or virtually, as mediated by communication technology, such as telephone conference call, video conference. Meaning of meeting. Meeting refers to a formal or informal deliberative assembly of individuals called to debate certain issues and problems and to take decisions. It is a gathering of two or more persons who come together for important discussion and decision on lawful matters. Requisits of a valid meeting. The following conditions must be satisfied for a meeting to be called a valid meeting. 1. Proper authority. The proper authority to convene a general meeting of a company is board of directors who should pass a resolution to call meeting at a duly convened board meeting. 2. Notice of meeting. Proper notice of the meeting should be given to the members by at least 21 days prior to the commencing of the meeting. 3. Quorum of meeting. The quorum is generally fixed by the articles. Quorum means the minimum number of members who must be present in order to constitute a meeting and transact business thereat. 4. Chairman of meeting. A chairman is necessary to conduct a meeting. 5. Minutes of meeting. Every company must keep a record of all proceedings of every meeting. Essentials for a meeting. The following are essential for any valid meeting to be recognized as follows. 1. Notice. Notice is a legal communication about the day, date, time and venue of the meeting. Under company law, there should be a 21 days clear notice to hold a meeting of the members of the company, whereas a 7-day notice is required to hold a meeting of the board of directors. 2. Agenda refers to the business to be transacted at the meeting. These are the list of programs, issues and problems to be discussed at the meeting. 3. Quorum. Quorum refers to the minimum number of members who must be present at a meeting in order to constitute a valid meeting. A meeting without the minimum quorum is invalid and decisions and proceedings held at meeting are invalid. The articles of a company provide for large quorum, 5 members personally present in the case of a public company and 2 members personally present in the case of a private company shall be the quorum for a general meeting of a company. Corporate Administration. 4. Proxy. Where a member is not able to personally attend a meeting, he can depute another person to attend the meeting on his behalf. A member may appoint another person to attend and vote at a meeting on his behalf. Such other person is known as proxy. 5. Chairman. The chairman is the head of the meeting. Generally, the chairman of the board of directors is the chairman of the meeting. If there is no chairman or he is not present within 15 minutes after the appointed time of the meeting or is unwilling to act as chairman of the meeting, the directors present may elect one among themselves to be the chairman of the meeting. 6. Voting and demand for poll. Matters are decided at a general meeting by a show of hands. Voting by a show of hands operates on the principle of one member, one vote. However, since the fundamental voting principle of a company is one share, one vote. 7. Amendment. Amendment means any modification to a motion before it is put to vote for adoption. Amendment may be proposed by any member who has not already spoken on the main motion or has not previously moved an amendment thereto. 8. Adjournment. Adjournment means suspending the proceedings of a meeting for the time being so that the meeting may be continued at a later date and time fixed in that meeting itself at the time of such adjournment or to decide later on. Minutes of meeting. The minutes of meeting are a summarized written record of what occurs and is said at a meeting. They typically describe the events of the meeting, starting with a list of attendees, a statement of issues considered by participants and related responses or decisions for the issues. The meeting minutes generally consist of the following information. 1. Date of meeting. 2. Subject or purpose of the meeting. 3. A list of the attendees. 4. Administrative issues discussed and the name of the individuals. 5. Concerns, opposition, questions raised by meeting attendees. 6. Closure. A minutes book should be maintained separately for meetings of the members and of the board of directors. The chairman of the meeting should initial each page and sign the minutes book at the end of each meeting. Corporate administration. Types of meeting. Company meetings may largely be divided into various categories according to their need and purpose for the business. They are as follows. 1. Statutory meeting. 2. Annual General Meeting, AGM. 3. Extraordinary General Meeting. Statutory meeting. It is the first meeting of the shareholders of a public company. It is held once in the lifetime of any public company. Section 165 of the Companies Act states that every company limited by shares or limited by guarantee in having a share capital must hold a general meeting of members of the company within a period of not less than 1 month and not more than 6 months from the date of incorporation of company. It is called statutory meeting. Purpose of statutory meeting. The main objective to hold a statutory meeting is to notify the share regarding the facts involving shares taken up, money received, contracts entered into, preliminary expenses, etc. Contents of statutory report. 1. The total number of shares allotted. 2. The total amount of cash received by the company in respect of all shares allotted. 3. An abstract of the receipt and payment and the balance of each cash and bank accounts in hand and an account of preliminary expenses. 4. Any commission or discount paid or to be paid on the issue or sale of shares or debentures. 5. The names, address and occupations of directors, auditors, manager and secretary. 6. Particulars of any contracts to be submitted to the meeting for approval and modifications. Done or proposed. 7. The arrears, if any, due on calls from every director and from the manager. 8. The particulars of any brokerage paid or to be paid in connection with the issue or sale of shares or debentures to any director or to the manager. Annual General Meeting, AGM. An annual general meeting is a meeting that official bodies and associations involving the public, including companies with shareholders, are often required by law. An annual meeting called by the directors of a company that allow shareholders to stay informed and involved with company decisions and workings. Annual general meeting must be held by every type of company, public or private, limited by shares or by guarantee, with or without share capital, or unlimited company, once a year. A company may hold its first annual general meeting within 18 months from the date of its incorporation. Corporate administration. Agenda at annual general meeting. At every AGM, the following matters must be discussed and decided. 1. Consideration of annual accounts, director's report and the auditor's report. 2. Declaration of dividend. 3. Appointment of directors in the place of those retiring. 4. Appointment of and the fixing of the remuneration of the statutory auditors. Extraordinary General Meeting. An extraordinary general meeting is a meeting of members of an organization, shareholders of a company or employees of an official body, which occurs at an irregular time. Every general meeting other than the statutory meeting in the annual general meeting or any adjournment thereof is an extraordinary meeting. Such meeting is usually called by the Board of Directors for some urgent business which cannot wait to be decided till next AGM. Concept of resolution. A resolution is the legal form of a decision taken at a meeting. A resolution is the final form of a decision taken at a meeting by voting on a motion, with or without amendment. Essentials of resolutions. The essentials to constitute a special resolution are as follows. A. Notice to the meeting should state that the resolution shall be passed as a special resolution. B. A 14-day special notice to be given to all shareholders. C. An explanatory note, stating the circumstances and provisions of law as to why the resolution should be a special resolution, should be appended to the notice of the meeting. D. The resolution shall be passed by a majority of not less than 75% of the meeting present in person. E. Law provides that if an ordinary resolution is passed where a special resolution is required. F. Any decision to be taken by the Board of Directors shall be by way of a board resolution. Types of resolutions. Company decisions are made by passing resolutions. Resolutions are passed both by the company's members and by its directors. 1. Members' resolutions. 2. Directors' resolution. Corporate administration. Members' resolutions. There are two types of resolution: ordinary resolutions and special resolutions. The Companies Act 2006 provides Sec. 282 ordinary resolutions. 1. An ordinary resolution of the members of a company means a resolution that is passed by a simple majority. 2. A written resolution is passed by a simple majority if it is passed by members representing a simple majority of the total voting rights of eligible members. 3. A resolution passes at a meeting on a show of hands is passed by a simple majority. 4. This type of resolution is necessary to take decisions on ordinary matters of the association. 5. Formalities for passing such a resolution, unlike a special resolution, are not so strict. 6. Anything that may be done by ordinary resolution may also be done by special resolution. 1. A special resolution of the members of a company means a resolution passed by a majority. Section 283 Special Resolution of not less than 75%. 2. Such resolutions are necessary when any decision has to be taken affecting the very constitution of the organization, e.g., altering the objects of the organization. Directors' resolutions. All resolutions are passed by a simple majority. There are no statutory provisions, so any rules must be found in the company's articles. 1. A decision of the directors is taken in accordance with the article. 2. Decision may take the form of a resolution in writing. Motion. Motion means a proposal to be discussed at a meeting by the members. A resolution may be passed accepting the motion, with or without modifications, or a motion may be entirely rejected. Distinguish between MOTIO and resolution. Black circle: a motion is a proposal from a member of the meeting, whereas a resolution reflects the general opinion of the board. Black circle. Not all motions can be resolutions, but all resolutions come from motions. Black circle. A motion can be put forward verbally, whereas a resolution is written down and recorded.